Hi everyone, welcome to part 2 of the lecture on indefeasibility of title and interest. In part 1, we looked at section 3402A, which actually has fraud or misrepresentation. So today we will be continuing with the fraud as well as misrepresentation and how that can affect our transactions. Misrepresentation is something that is very important because sometimes a person enters into a transaction based on what was represented to him. And if it is not what was represented, then of course we are talking about misrepresentation. Let us look at the case of Chong and another and Yong. Now, in this particular case, you find that this person was allowed to use the lands. And when the plaintiff wanted the lands back, he said, "No, I have bought it from the previous owner, and he is now the legal owner." The defendant claimed that he had purchased the lands from the appellant in this case, but he couldn't produce a sale and purchase agreement. He couldn't produce a receipt. He only claimed he had a title. So the plaintiff checked and found there was no evidence, and therefore plaintiff claimed that the transfer was fraudulent. The defendant's story was that he waited for some years for the plaintiff's father, in this case, to hand over the issue document of title to him. And these titles were not forthcoming. But he said he was the owner. Something was not quite right. The plaintiffs therefore checked all the entries in the presentation book for 1969. That was the year that the defendant said he had bought the lands. There was no record of any such dealing. So something was brewing here. The trial judge took the stand that the plaintiffs had failed to prove fraud against the defendant beyond reasonable doubt, which we all know is not the standard of proof for civil cases. For civil cases, you have to prove on a balance of probabilities. So they went on appeal. During the appeal, the plaintiffs wanted to have fresh evidence because they had obtained some information. And they said that a transfer had effected, or rather had been effected, March 1975. And this had been removed from the Register of Documents for 1975, lost from the possession of the Selama Land Office. The plot thickens. The plaintiff now sought to adduce as evidence another letter saying that the document was lost. And attached to that letter, there was evidence that the defendant had declared he had lost the issued documents of title to the lands. So, of course, the defendant would not want this fresh evidence to be adduced on appeal, understandably. So, what was the decision of the court? The court permitted the fresh evidence to be adduced, and, of course, the appeal was allowed. There was clearly a fraudulent transaction that had taken place here. The defendant had claimed that the titles were lost. He had made a statutory declaration and then applied for fresh titles. So with that, he thought, okay, I am now the registered proprietor of such lands, and therefore I will get indefeasibility of title. However, such indefeasibility could be defeated by proof of fraud or misrepresentation to which the defendant was party or privy to. In obtaining the titles, claiming they were lost, the defendant had misrepresented. Therefore, he had no right to hold on to the title. That title had to be set aside. He was party or privy to the misrepresentation. Which then brings us to the question, what if an agent had conducted that and subsequently had been transferred into the defendant's name? Agent will also be a party or privy to the fraud, and the defendant's title will then again be set aside. If you look at the case of Do Shi and Yo Tiong Lei. So now we have more cases of fraud and misrepresentation. In terms of fraudulent transaction, it must be actual fraud. We have done this in detail in part 1. Actual fraud, not constructive fraud, not imputed fraud. And the case of Waimiha Sawmilling Company demands attention here. Datuk Jaginda Singh's case is another classic case where Tara Rajaratnam was made to sign. She actually signed, but was under the impression that it was for a loan and not an actual transfer. The document of transfer had been inserted among the other papers. And in the case of Lockhew and Port Swettenham, Mr. Glass, who represented Port Swettenham, told Inche Bakar, I believe, that the 54 acres of land which Ms. Inche Bakar held would not form part of the whole block that would be transferred to Port Swettenham. Inche Bakar agreed, but at the end of the day, it was the whole land, including his 54 acres, that was transferred, and therefore that had to be set aside. So moving on to forgery now, we have section 3402B, which talks about forgery or an insufficient or a void instrument. However, there is a significant difference here. In terms of forgery, insufficient or void instrument, the person in whose name it is transferred need not be a party or privy to the forgery. How that will happen is quite difficult to imagine, because under the Torrance system, using the curtain and mirror principle, we're supposed to be dealing with the person, meeting him face to face, seeing his IC and seeing the title to make sure that's all, that X with the same face as in the IC, the same name and the same number, IC number, and that appears on the title, then you are dealing with the person. So how could forgery happen? But sometimes it is possible, I guess, as you will see in the case of Adorna, the famous landmark case, famous for all the wrong reasons. And then we find that, so according to what the land code says, where registration was obtained by forgery, as long as it can be shown that the document was forged, then the registration can be set aside. The person does not obtain an indefeasible title. So there are articles here, Professor Teo Kiang Soot's article, also my own article that was written in 2011. Please do read these articles. So as I said, the Adorna case is a landmark case, but not in a very good way, because the Adorna case held that Section 340 NLC, especially 2B, conferred immediate indefeasibility. This became the subject of many criticisms, as it had caused some injustices to landowners who were defrauded of their lands. At this point, please refer to part 1 of this video where we had discussed immediate and deferred indefeasibility. However, 15 years after Adorna, Tan Ying Hong and Tan Sien Sen rectified or remedied the situation. It was a decision that was welcomed by many, as the federal court overruled its own decision in Adorna Properties and held that Section 340 of the NLC in fact confers deferred indefeasibility, not immediate indefeasibility. A comprehensive discussion can be found on this link that I have provided. A good observation to be followed would be the case of Brett Andrew, McNamara, and Kamli Kwan. He says, where the words used are clear and unambiguous, it is not the court's business to go behind those written terms or to read new terms to it. So the famous proviso comes in, but this proviso is a very important proviso, for what it does is when a person gets a title and it is set aside, let's say liable to be set aside under the circumstances in 3402A, B, or C, but that person had subsequently either sold the property to a third party or created a registered interest in favor of a third party, then the third party has the benefit to the proviso in section 340 subsection 3. So I will let you read 340 subsection 1 and section 3402A, B, and C. We are talking about 3 circumstances whereby the title may be set aside. And then we come to section 3403, where the title or interest of any person or body is defeasible by reason of any of the circumstances specified in subsection 2. A. It shall be liable to be set aside in the hands of any person or body to whom it may subsequently be transferred. And any interest subsequently granted thereof shall be liable to be set aside in the hands of the person or body in whom it is for the time being vested. So, for example, if A had bought a piece of land, or going back to Hu Kok Chong's case, the defendant had got the land by fraud. He was party and privy to the fraud. But if the defendant had either sold it to X, then X will fall under A. X still doesn't have a good title, remember. Or the defendant had created a charge in favor of Bank Rakyat. Bank Rakyat will fall under B. But remember, Bank Rakyat's charge is also defeasible because it can still be set aside. How the proviso comes in. Provided that nothing in this subsection shall affect any title or interest acquired by any purchaser in good faith and for valuable consideration, or any person or body claiming through or under such a purchaser. There was a lot of hue and cry about the word purchaser, saying that it did not apply to charges, but it does. Purchaser means the person who purchases. It could be someone who purchased the land or someone who had given collateral on the basis of the title. And what is the effect of a proviso here then? The case of Rogers and Resi-Statewide, although 1991 is still good, it is a cardinal rule of interpretation that a proviso can only apply to that particular section or subsection. And in this case, we are talking about the proviso applicable to subsection 3 of the NLC. It does not give immunity from adverse claims to a bona fide purchaser who claims title by registration of a forged instrument. Because honestly, I don't think you can come across a scenario where a forgery can happen and you don't know about it. So the object of a proviso is to carve out from the substantive section or clause of a statute a class or category of persons or things to whom or to which the main section does not apply. The proviso cannot be divorced from the main clause to which it is attached. Sarawak, the position is governed by section 132. And here, it is clear under section 132 that the indefeasibility of title is not defeated by the illegality of the document or instrument of title. And therefore, we can say position in Sarawak attaches immediate indefeasibility. Okay. Standard of proof. Now, what is the standard of proof that we are looking at? In the case of who, we found that the standard of proof has to be on a balance of probabilities for civil cases. And we cannot go on a very strict approach as the High Court did in the case of who, that, beyond reasonable doubt. It is a balance of probabilities. So I will now leave you with more cases for your reading pleasure. And all of these cases have been decided after the case of Adorna, but none of them have really got the impact that Tan Ying Hong made. As for the latest cases that has already been given to those who are following this course online and registered with our intensive program. So enjoy your reading. And thank you. Thank you very much for listening to this lecture. Please don't forget to hit the like button and subscribe to make it more pleasurable for me to make the videos. Thank you. Bye-bye.